present their arguments before such luminaries. Allow me the privilege of introducing our judges. Honorable Mr. Justice Sandeep Sharma, Judge, Himachal Pradesh High Court, Shimla. Respected Professor Dr. Sanjay Sindhu, former Dean and Chairperson, HPU Shimla. Respected Mr. Piyush Verma, President Bar Association, HP High Court, Shimla. Respected Mr. Neel Kamal Sood, Senior Advocate, HP High Court, Shimla. Respected Mr. Vijay Kumar Arora, Senior Advocate, HP High Court, Shimla. We are profoundly grateful for their time and expertise and look forward to their valuable insights during this round. At this juncture, it is my duty to cede with the proceedings to the Honorable Bench. I invite our distinguished judges to assume the control of the court. Thank you.
Good afternoon, everyone. I, Petitioner Srivastava, greet you all on behalf of Moot Court Committee, HPNLU, Shimla, and I will be the court master today for this round. For this session, we have Team Code 510 as petitioners and Team Code 501 as respondent. I request Speaker number 1 of both the teams to kindly apprise me with the time division between the speakers of the respective teams.
Both the councils will be taking 23 minutes and we respectfully reserve 4 minutes for it.
Thank you.
The speaker 1 will be taking 30 minutes, the speaker 2 shall be taking 24 minutes, and we have reserved 3 minutes as a sole rebuttal.
Thank you so much. With that, the participants are requested to maintain the decorum of the courtroom. With the permission of the judges, I request the team representing the petitioner side to kindly begin with the competition. Good luck to both the teams.
Council seeks permission to begin. The council seeks permission to address the bench collectively as your lordship. Warm greetings, your lordship. May it please this honorable court. That this is the council number 1, TC 510, appearing on behalf of the petitioners in the instant case of Liberty Matters versus Republic of Aurora, heard along with Dr. Jeremy Comte versus Directorate of Financial Integrity and the suo motu petition dealing with the voting rights of under trial prisoners. Your lordships, the petitioner and the applicant have approached the Honorable High Court of Nirvana under Article 226 of the Constitution of Aurora and Section 47 of Prevention of Money Laundering Act 2000. The council seeks permission to briefly state the facts. Much obliged, your lordship. The elections for the state of Nirvana, which is one of the 5 states of Republic of Aurora, have just concluded. The 2 major parties that contested the elections were ANOP, that is Aurora's National Optimistic Party, and the second party was NYP, that is Nirvana Youth Party. NYP was under the leadership of Dr. Comte, who had introduced Nirvana IT employment scheme last year, which served as the frontline policy for this year's re-election, as people were very happy with this employment policy. Further, just a few days prior to the election, a Westarian citizen named Mr. Robin Hood Spencer, he filed a complaint with Aurora's NBI alleging that Nirvana-based call centers, which were part of this IT employment scheme, they were involved in a large-scale international fraud, falsely promising cheap loans to Westarian citizens. Following Mr. Spencer's complaint, the NBI arrested Dr. Comte and his aides on charges of cheating and conspiracy. However, they were later released on bail. And on the very same day, the DFI, that is the Directorate of Financial Integrity, they arrested Dr. Comte on the charges of money laundering, alleging that he had funneled fraudulent funds to a Hawala transaction. His subsequent bail application was denied under Section 45 of PMLA. At the same time, a civil liberties group named Liberty Matters, they filed a petition before High Court of Nirvana, challenging the constitutionality of these stringent bail conditions and raising issues of personal liberty. Further, the High Court has also agreed to suo motu deal with the issue of right to vote of under trial prisoner. Your lordships, the council now seeks permission to begin with the first issue. Much obliged. The first issue is whether Section 45 of PMLA, which imposes stringent bail conditions, violate fundamental rights of guaranteed under Constitution of Aurora. It is our humble submission that the stringent conditions as provided under Section 45, they are violated of Article 21 and Article 15. And the same we shall be proving in a twofold manner. First, we shall be establishing that the reverse burden of proof that is provided under Section 45 of PML is violative of Article 21. And our second argument would be that the twin conditions are violative of Article 14. Beginning with my first submission, the Section 45 say the twin conditions under Section 45 states the first condition is that the public prosecutor has to be given an opportunity to oppose the application for such release. And the second condition is that when the public prosecutor opposes the release, then the court has to be satisfied that there are reasonable grounds for believing that he is not guilty of such an offense, and that is that he is not likely to commit any offense while on bail. The phrase that he is not guilty indicates the reverse burden of proof that is put on the arrestee at the time of bail, which is at a pre-trial stage. It is our submission that presumption of innocence is a cardinal principle of criminal jurisprudence. The right has been recognized under International Covenant on Civil and Political Rights, Article 14, and even under Article 11 of UDHR. Further, the Rome Statute, which is known for prosecuting some of the most heinous offences, such as genocide, even under Article 66 of the Rome Statute, it clearly provides for presumption of innocence. Therefore, the principle that we can deduce from all the criminal laws and the international legal framework that is available is that grant of bail is the rule and jail is the exception. Therefore, we submit that liberty of the individual is always a rule and deprivation is the exception. And this principle is only a paraphrasing of Article 21, which states that no person can be deprived of life and personal liberty as per procedure established by law, as held in the case of Prem Prakash versus Union of India, 2024 Supreme Court. Para 11, it is on page 20 of our compendium. Your Lordship, moving further, the purpose for imposing conditions while granting bail is to secure the presence of accused at trial, and it is also to ensure that the accused does not tamper with witnesses or evidence. Nowhere it has been mentioned that bail has to be used as a punishment. In fact, in the case of Javed Ghulam Nabi versus State of Maharashtra, which is on page 8 of our compendium, it clearly states that bail cannot be withheld as a punishment. An accused person who enjoys freedom is in a much better position to defend his case and to properly defend himself, and he cannot properly defend himself if he were in a custody. Then further, at this stage, it would not be out of place to mention that similar legislations dealing with prevention of money laundering act in other countries. So, for instance, United Kingdom, they also have a specific provision dealing with the offense of money laundering. However, their provision does not have any such twin conditions or reverse burden of proof. Further, if we look at the recommendations by International Financial Task Force, they have nowhere recommended that twin conditions should be imposed or reverse burden of proof should be there in a statute governing the offense of governing the offense of money laundering. In fact, the Financial Task Force has disparaged the reverse burden of proof among nations. Therefore, we submit that there is no international recognition of twin conditions or the reverse burden. Further, Your Lordships, the procedure that is mandated under Section 45(1) of PMLA for granting bail is not fair, just, or reasonable. As firstly, the court has to be satisfied on the material provided at the pre-trial stage when the investigation is undergoing. So, at this point, the charge sheet has not been filed; the investigation is still going. At this particular juncture, the court has to decide whether the accused or the arrestee is not guilty of the offense. And this the court has to decide on the basis of the material that is provided, which is majorly the material provided by the DFI or the ED. Now, over here, the court in the case of Vijay Madan Lal Chaudhary has clearly stated that PCIR is not a public document. You do not have to provide it to the arrestee. So the arrestee is not left with any document through which he or she can understand what are the grounds of arrest or what is the case that is being made out against him or her. And at such a point, the arrestee has to prove that he is not guilty when he is not even aware of the grounds. Therefore, we submit that this particular provision directly goes against Article 21, which provides for personal liberty. Further, our second submission in this regard is that Section 45 imposes burden on the accused, which is nearly impossible to discharge. outcome is basically prejudicial to the accused and is also violative of the fair and reasonable procedure that Article 21 states. Further, Your Lordships, even if we consider money laundering to be a very heinous and a serious offence, even then, for a heinous crime like murder, which shocks the conscience of the entire society, the presumption of innocence is still in favor of the accused. Over there, there is no reverse burden of proof. And secondly, we submit that for granting bail under BNSS, severity of offence is always seen. So the court, while granting bail, takes into account the severity and the nature of the offence. Therefore, we submit that the same condition should be applied to the offence of money laundering as well. Further, Your Lordship, the reason why we are stating that further, Your Lordship, the reason why we have the principle of innocence, innocent until proven guilty, is to ensure that not a single person is wrongfully convicted of an offence for which he did not commit. And the same I'll try to explain with an example. Your Lordship, under Section 3 of PMLA defines the offence of money laundering. And money laundering is usually committed in a three-stage manner. So there is placement, clearing, and integration. Lordship, let's assume there's a person X who is involved in the offence of money laundering. He has laundered some amount and he wants to integrate into the economy. So what he does is by way of this amount he purchases a flat. How now a bona fide buyer, why he purchases this flat from X. Now let's say the DFI gets to know about this conspiracy and the proceeds of crime. So what they will do is that they will arrest X and Y under the offence of money laundering. Now, the one who is a bona fide purchaser would have to prove that he is not guilty of the offence. He was a bona fide purchaser. He did not know about the conspiracy. He was under the genuine belief that the house that he has bought is a bona fide house. He did not know it is tainted. It is a tainted property. At this particular stage, he will be asked to prove under Section 45 that he is not guilty when there are no safeguards attached to it. Therefore, we humbly submit that it is violative of Article 21. Your Lordships, moving to the second limb of my argument, that is violative of Article 20. In this regard, we submit that indeed the concept of equality, it allows for differential treatment. However, it prevents distinctions that are not properly justified or when there is no reasonable basis for classification. The reverse burden of proof as provided under Section 45, it does not stand the validity of Article 14 as it is manifestly arbitrary in its application. Your Lordships, under the current scheme, the accused is subject to two different procedures and the safeguards are nowhere uniform. Therefore, we submit that it is in violation of Article 14. Further, Your Lordship, there is no legitimate aim or reasonable nexus as twin conditions are applicable on all the predicate offences. If we look at the rationale behind enacting Prevention of Money Laundering Act and the rationale behind including scheduled offences, so this report of Standing Committee on Finance 1999, they had explained what exactly is scheduled offence. They had stated that the term scheduled offence is thought to be defined in terms of serious crimes under the Indian Penal Code, the Prevention of Corruption Act, NDPS, Arms Act, Immoral Traffic Prevention Act 1956. So initially there were only these six schedules, only these six statutes that were present in the schedule. And he had also mentioned one very important thing. It is proposed to narrate the specific crimes under these acts, being the crimes which lead to generation of large illegal funds. This is the main aim of Prevention of Money Laundering Act, to prevent large illegal funds. However, if you look at the current scheme, they have included every act under the umbrella of scheduled offences. So, for example, a person who receives some property under Plant Variety Act or Water Act, that person is situated similarly with the person who is using funds for terror funding. Therefore, we submit that it treating unequals and equals alike, and therefore it is violative of Article 14. Further, Your Lordships, the respondents may argue that such twin conditions are present in other statutes and they have been held to be constitutional. So, for instance, UAP and NDPS do contain such twin conditions. So, it is our humble submission that the onerous conditions are needed in those statutes because of the nature and gravity of the offence. Also, if you look at the threshold, so under those statutes, the court only has to examine whether the allegation is prima facie true or not. But if you look at PMLA over here, the court has to reach a finding that there are reasonable grounds for believing that the accused is not guilty before granting bail. Therefore, we submit that the threshold is higher and it is different from the twin conditions of UAP and NDPS. Our second argument in this regard is that the deep restrictive conditions under UAP and NDPS, they are restricted to only some parts of the act, so NDPS and UAPN. However, if you look at PMLA, these restrictive conditions are applicable to all the predicate offences. So, if a person has to seek bail for any predicate offence, the conditions remain same. Thus, we submit that Article 45 is violative of Section 45. I'm so sorry. Section 45 is violative of Article 21 and 14. Your Lordships, if the council seeks permission to begin with the second issue. Much obliged, Your Lordship. In regard to the second issue, we submit that the arrest of Dr. Jeremy Comte was violative of Article 21 and 22. Your Lordship's Article 21 clearly states that no person can be deprived of life and personal liberty except as provided by law. Section 19 of PMLA deals with the power of arrest and it lays down three conditions. The first condition is that the officer must have material in his possession. The second condition is that on the basis of such material, the authorized officer should form and record in writing the reason to believe that the person to be arrested is guilty of an offence and punishable under PMLA. And the third condition is that the person arrested, as soon as may be, must be informed of the grounds of arrest. Your Lordships, in the instant case, the arrest violates Article 21 and 22. Firstly, as no written grounds of arrest were provided. In the case of Pankaj Bansal versus Union of India, which is on page 33 of our compendium, the Lordships could please refer to para 45. Your Lordship, in this particular case, it was clearly held that it is a fundamental and statutory right to be informed about the grounds of arrest in writing, and the copy of such written grounds of arrest have to be furnished to the arrested person. The purpose of providing this information is that this information would be the only effective means for the arrested person to consult his advocate, oppose the police custody, and to seek bail. It is only if the arrested person has knowledge of these facts that he or she would be in a position to plead and prove before the special court that he or she is not guilty of the offence. The right to be informed about the grounds of arrest also flows from Article 22 of the Constitution and also ICCPR. And therefore, we submit that any infringement of this fundamental right, it would vitiate the process of arrest. Further, Your Lordships, in the case of Prabir Purekas versus State NCT of Delhi, which is at page 23 of our compendium, para 49. Your Lordship, in this particular case, the court had differentiated between grounds of arrest and reasons of arrest. The court had stated that grounds would have to be personal in nature and specific to the arrestee, and reasons are general in nature. Secondly, the court also mentioned that the grounds of arrest would require to contain all such details in hand of the investigating officer which necessitated the arrest of the accused. In the instant case, Your Lordship, Dr. Comte, he was merely provided with an arrest memo which does not mention date and time of arrest. Secondly, it only states general reasons for arrest and it fails to provide sufficient material necessary for him to build an adequate defense in order to get bail. Further, the arrest memo also fails to further on the very same day, the DFI released a very detailed press note of the investigation, which is on Moot proposition page 8, para N. Your Lordships, although the DFI officials do have the power to redact some of the sensitive material that may be found in the investigation, however, there was no such sensitive material involved in the present case because on the very same day they are releasing a press note, which is a very detailed press note. And if we look at the annexure 2 of the Moot proposition, on which we have the arrest memo over there, if we read the reasons of arrest, the reasons of arrest are very abridged and insufficient and provide insufficient information. Therefore, it is our submission that Dr. Comte was deprived of the necessary details in order to effectively contest the charges or even to prepare an adequate defense. And this failure, it constitutes a violation of the procedural safeguards as enshrined under Article 22 of the Constitution. Your Lordships, moving to the second limb of my argument, that is, the DFI officials also have the duty to provide reasons to believe to the accused, which was not done so in the present case. The Lordships, it is submitted that in the court in the case of Arvind Kejriwal versus Directorate of Enforcement, para 36, which is on page 39 of our compendium. The Lordships, in this particular case, the court had stated that providing written grounds of arrest, though it is a must, it only satisfies the first compliance requirement. The authorized officer's genuine belief and reasoning based on the evidence that establishes the arrestee's guilt is also the legal necessity. Further, the case of B. Senthil Balaji versus State, it clearly states that a designated officer can arrest only once they have recorded reasons to believe in writing. And it is mandatory to furnish these reasons to the arrestee, which was not done in the present case. Therefore, we submit that the arrest of Dr. Jeremy Comte was unlawful and unconstitutional, as it fails to abide by Section 19 of PML. Your Lordships, now my co-counsel, if there are no questions, my co-counsel would be dealing with issue 3 and issue 4. It was a pleasure arguing before this. Yes, sir.
Clarify one thing. You have mentioned about the EMLA, the section 45, about the procedure is not properly followed. But so far as the provisions of the CRPC is concerned, that has been excluded from the EMLA. So how do you justify?
Your Lordship, the provisions of CRPC are only excluded to the extent that they are inconsistent with PMLA. Otherwise, the provisions of CRPC do apply, as mentioned in the section 65 of PMLA.
How will you apply the presumption of innocence?
Your Lordship, since PMLA is a special legislation, section 45 is a specific provision dealing with bail. Therefore, when it comes to bail, reverse burden of proof would be applicable because it is a specific special legislation. And section 65, which talks about application of CRPC provisions, it clearly states that CRPC provisions would be applicable as long as they are not inconsistent. But over here, since we have different bail provisions, so of course the special provision of bail as mandated under section 45, that would be followed.
Take case and details. LLP section 37 is same. Both section 36, 37 say that bail cannot be done because certain conditions are needed. And even in that enactment, ultimately, which procedural code is taken note of. Similarly, if you take the SC/ST Act, it's a special enactment. So you could take assistance of these acts also. Because here, section 545 and section 37, parameter is same.
Yes.
You have specifically mentioned reason to believe, and you have taken care of the Arvind Kejriwal judgment in the meaning exactly reason to believe in legal terms. But you have only referred Arvind Kejriwal, but there you have referred Kejriwal. Reason to believe, because in economic offences it is very important. Please elaborate.
Indeed, Your Lordship. So the reason to believe has been discussed in the case of actually discussed by the court in the case of Arvind Kejriwal. They have explained. If I can read the relevant paragraph, they explain. So in paragraph 27, which is on page 36 of our compendium, this date.
29 up to 29.
Yes. Your Lordship. So it states on reading of reason to believe, the court must form secondary opinion on the validity of exercise undertaken for compliance of section 19(1) of PMLA. The reason to believe that the person is guilty of an offence under PMLA should be founded on the material and form of documents and oral statements. Further, they state that here the reason to believe has to be distinguished, and it is not same as grave suspicion. It refers to the reasons for formation of the belief, which must have a rational connection with or an element bearing on the formation of belief. The reason should not be extraneous or irrelevant for the purpose of the court.
So we always insist that the reason of arrest should be informed. Because even at that stage, officer who may have come for arresting, he may have something in his hand. Then you can say that what is this reason to believe? He would be showing out documents on. He have reason to believe after choosing these documents. He needed to learn.
Thank you very much.
Greetings to the bench. The council seeks permission to begin this collection for the issue number 3 and 4. Much obliged, your lordship. The council for petitioners humbly submit that the arrest of Dr. Jeremy Conte violates both the principle of proportionality under Article 21 of the Constitution of Ireland and also the right to free and fair elections. Your lordship, the crux of the arguments is hinged upon the two main points. Firstly, the arrest infringes upon Dr. Conte's right to personal liberty and fails the proportionality test. And secondly, the timing of the arrest disrupts the democratic process, violating the rights to freedom of rights to free and fair elections. Your lordships, the right to life and personal liberty is guaranteed under Article 21 of the Constitution of Ireland, and any deprivation of this right must meet to the test of proportionality. The principle of proportionality is a crucial doctrine in the protection of constitutional rights, and it mandates the actions of the actions infringing the fundamental rights must be carefully balanced with the legitimate aims pursued. Your lordships, I would like you to take to the case of Coimbatore District Central Corporation Bank, mentioned on the page 78, paragraph 18 of that case of the compendium submitted. Your lordships, the court, when the Supreme Court explained us what proportionality means, it means that it is a doctrine or principle which a court is concerned, which powers the method or manner in which the decision maker has placed his prudence on. The endowment jurisprudence, your lordships, regarding the proportionality was discussed in the modern dental college case. Mentioned in page 67 of the compendium submitted, the para 69 of the case lays down the four conditions which become the four pillars logically of the principle of proportionality. The first one, whether the state action serves a legitimate goal. Second, whether there is a rational connection between the means adopted and the goal. Third, whether less restrictive means could achieve the same result. And fourth, whether the impact of the individual's rights is disproportionate to the beliefs of to the benefits of the measure. Your lordships, in the present case, the arrest of Dr. Comte fails to meet the requirements of necessity and proportionality. The investigation into the alleged money laundering and international fraud does not justify the timing, need, and the manner of arrest, especially considering Dr. Comte's full cooperation with the investigating authorities. Your lordships, Dr. Comte, we must keep into consideration that Dr. Comte had already been granted bail in the prior proceedings under the Aurora Nyaya Sanhita ANS for the charges of criminal conspiracy and cheating. He had fully cooperated with the investigation by the National Bureau of Investigation (NBI), and there was no evidence to suggest that he intended to obstruct or abscond the justice at any point of time. His arrest by the Directorate of Financial Integrity (DFI) for the money laundering just days before the elections in the state of Nirvana raises concerns about arbitrariness and disproportionality. Your lordships, Section 19 of the Prevention of Money Laundering Act (PMLA) 2002, an arrest can only be made if the authorized officer has reasons to believe, which my co-counsel has fully elaborated, that the individual is guilty of the offence. In this case, however, the DFI has failed. In the present case, however, the DFI has failed to provide the substantial material to justify this belief. The arrest memo was vague, merely citing Dr. Comte's alleged involvement in an international fraud without specific details or evidence provided to him. Even your lordship, the complaint lodged by Mr. Robert Spencer categorically states that the entire fraudulent operation in the Republic of Wisteria is believed to be carried out to the state of nirvana, failing the balancing test, your lordships. Coming back to the reasons to believe, your lordships, as held by the Honorable Supreme Court in the Premium Granite versus State of Tamil Nadu, para 49, page 86 of the compendium, the Supreme Court held that the reasons to believe must be based on an objective material and not arbitrary discretion, which whose base were basically laid down in the case of Pankaj Bansal, para 19, page 28 of the compendium submitted, where the Honorable Apex Court established that Section 19 mandates the investigating officer must have reasons to believe, exercise his powers of arrest against the accused. Your Lordship, the international perspectives of a Canadian court in the para 12 of the case of Guilford versus Kelson, mentioned on page 13 of the memorial submitted, states that the reason to believe conveys a conviction founded primarily on the evidence present. Hence, it is of the higher standard than a mere suspicion. Your Lordship, the Supreme Court in the Vijay Madan Lal Chaudhary also held that the designated officer can arrest the accused only after reaching to the opinion that they are guilty of the offense. This determination has been backed by the material evidence. In the present case, no such material was provided to substantiate the claim that Dr. Comte was guilty of such offense and this arrest was necessary, failing to justify the object of the arrest, your lordships. Further, your lordships, the Supreme Court in the infamous case of Menaka Gandhi versus Union of India has held that Article 21 needs to be interpreted in an inclusive and broader manner. Your lordships, it's not about just protecting life, but also the dignity and liberty of the individual. By arresting Dr. Comte, your lordships, without proper necessary or justification, the DFI has violated his right to personal liberty and dignity. And arrest affects not only an individual's freedom, but also his reputation and self-worth that he has earned for over the ages in the country. Your lordships, the arrest was basically punitive in nature, seeking to tarnish Dr. Comte's reputation during an electoral campaign or electoral season that was going on in the state of Nirvana. Your lordships, rather than serving the needs of justice, its main aim was to tarnish Dr. Comte's image. The arrest was unnecessary given his cooperation, and the timing suggests that it was meant to cause maximum harm to the electoral process and not to serve an investigation. Your lordships, a common question that lingers on every legal mind after going through this case is that if DFI was in such an urgency that the process of crime would reach to a conclusion, or the process of crime might get into the mainstream of the electoral campaign, then they arrested Dr. Comte in a very hesitation and in a very early manner. But the same DFI had a time to release the press note on the very similar day, giving a detailed description of what Dr. Comte has done, rather than writing the same and citing the same in the arrest memo that was provided to him. Your lordships, Aurora is a democracy that elections are central to the governance process, and the fairness of these elections must be protected. The time of Comte's arrest just days before the Nirvana state elections jeopardized this fairness. Your lordships, I seek your kind attention to the case of Arvind Kejriwal mentioned on the page 94 of the compendium submitted. Your lordships, when we go to the para 8 of the judgment, the Supreme Court said that while examining the question of grant of interim bail/release, the courts always take into consideration the particularities associated with the person in the question and the surrounding circumstances. In fact, to ignore the same would be completely wrong. Your lordships, when we come to the present case, when the court has to consider, they must consider the circumstances that the Nirvana was in and also Dr. Comte's position to. Your lordships, Dr. Comte is not only the sitting chief minister of Nirvana, but also a key candidate for the Nirvana Youth Party, NYP, and a key face for the upcoming elections. By arresting him so close to the election, the DFI has disrupted the level playing field and giving an undue advantage to the national ruling party known as Aurora National Optimistic Party, ANOP, which has been weighing to take control of the state of Nirvana. Your lordships, the timing and the manner of the arrest suggest that this has been a politically motivated, aimed at undermining the electoral prospects of Dr. Comte and his party. This undermines the electoral process and raises the question about the misuse of investigative agencies at the political ends. Your lordships, the case comes from the land where in the case of Indira Gandhi versus Raj Narayan, the Supreme Court emphasized that any act that disrupts the free and fair elections undermines the democracy itself. Your lordships, in the present case, the arrest of such a major political figure just the days before election undermines the the electoral environment of this entire nation, and also amounts to an electoral interference which violates the constitutional right to free and fair election. Your Lordship, given the significance of our elections in the state of Aurora's democracy, we submit that Honorable Court must scrutinize the actions that have the potential to the interference with the integrity of the electoral process. Further, the arrest of Dr. Comte was not necessary, and the timing suggests that an attempt to influence the political environment in this context was done. The arrest was not just violation of the personal liberty, but also an assault to the democratic process itself, Your Lordships. Therefore, we submit that the arrest of Dr. Comte is unconstitutional. It violates the principle of proportionality under Article 21, infringes upon the right to free and fair elections also. We urge the Honorable High Court to declare the arrest unlawful and protect the integrity of Aurora's democracy. If your Lordships don't have any questions, the Council seeks permission to begin with the last issue.
This PML is clear that section 45 PMLA, which imposes stringent condition to granting the one is fundamental right guaranteed at the first. So precisely you need to determine the legality of this provision of law.
Yes, sir.
Let us explain how on count of arrest of Mr. Comte, there is a possibility of review of elections, or there is any apprehension that there won't be any free and fair election.
Your Lordships, much obliged for your question. I would like you to seek your kind addition to the page 3 of the fact sheet. If you go to the para A, Your Lordships, of the fact sheet, you will come to know from the very first line that the revengeful politics of ANOP is not a hidden factor to any of the people.
That cannot be ground to this.
No. I'm just complaining and coming to PMLA also. Yeah. So So the ANOP is not a hidden factor. Additionally, Your Lordship, the skipping of a major procedure.
You can base this ground that by arresting Mr. Comte at this time, virtually attempt is being made to order the democracy or to prevent him from participating in election. But how it would help you in getting this section declared unconstitutional?
Your Lordships, my co-counsel has answered the
While
question.
enlarging by seeking bail, that will be ground. The
Yes,
timing is very
Yes.
crucial.
Yes,
He
Your
was
Lordship.
all set to go for this election. He was heading one prominent political party.
Yes,
So this has been done purposely. This can be ground for bail.
Yes,
Coupled
sir.
with your other argument which has been advanced by your plea that at the time of arrest, no reasons have been assigned, no objective material has been given.
Yes, Your
One
Lordships.
thing which you further could argue, in terms of section 19, arresting officer while having some reason to believe should have some objective material before it.
Exactly.
Another question would arise when that material would be put to scrutiny. Veracity when we see, and probably answer would lie in Kejriwal's case.
Yes,
Why they have been granted bail? For these reasons only.
yes, Your Lordship.
These would be those.
Your Lordships, I would just like to give a clarification regarding this. The High Court is currently adjudicating the 3 matters. Firstly, is the bail application by the applicant Dr. Comte, as well as the matter filed by Liberty Matters, who are arguing for the constitutionality of the section 45. So in the present matter, when it was just about that the Dr. Comte's arrest was unlawful and it was violating the right to free and fair elections. My co-counsel previously dealt with the section 45 of PMLA and was quite clear about how the section 45 is violating the rights of the people, and that's why it should be considered.
The argument raised by the
Yes, Your Lordship.
that may not have much, balance with evidence.
Yes.
Present matter.
Yes, Your Lordship.
Please do it.
The Council seeks permission for the last part of the submission, the issue number 4. Your Lordships, the issue by the 62-5 of the Representation of Peoples Act 1951, which bars under trial prisoners from voting, is compatible with the Constitution's vision of equality and justice. We submit it is not. Your Lordships, just keeping every matter aside, Dr. Comte, the PMLA and everything, just imagine a hypothetical factual scenario. 2 professors, Mr. A and B, are walking down the mall. They have a very good reputation and good backing in their hand, and they were just enjoying and returning back to their home. Nearby, a theft had just taken place. A small electronics shop was broken into and expensive gadgets were stolen. Witnesses saw two men wearing black jacket and blue jeans doing the theft. Your lordships, coincidentally, Mr. A and B, who were in the similar clothing, were walking down in the area at the same time. A passerby who saw the suspect fleeing mistakenly identifies Mr. A and B as the thieves. The police find Mr. A and B near the crime scene and arrest him based on the evidence and under pressure to make an arrest, decide to detain him. Further, Your Worship, they also got the time for custody. Eventually, Mr. A, an ordinary citizen, Mr. A and B, who were an ordinary citizen previous night, became an under trial prisoners today. Your Lordship, if Himachal Pradesh state of Himachal Pradesh announces elections today, Mr. A and B are barred from voting. They are allowed to vote in snatched cause they were just under trial prisoners. Further, if we put a thought that Mr. B gets a bail and he's out of the prison, whereas Mr. A, due to lack of resources, some other kind, is not able to get out, then Mr. B's right to vote is restored, whereas Mr. A's restriction on right to vote still continues. Whether the section creating such a disparity is constitutionally valid or not, Your Lordships, the Council would like to place its arguments on the two major crux. Firstly, the right to vote is constitutional right, and secondly, the disenfranchisement is violative of the fundamental rights guaranteed by the Constitution of Aurora. Your Lordships, the Council would like to seek your attention towards the concern rooted in all the major democracies around the globe. Under Article 21 of UDHR, as well as under Article 326 of the Constitution of Aurora, that everyone has a right to take part in the government of his country directly or by choosing the representative in a free and fair manner. Barring under trans, Your Lordships, is not only denies the constitutional rights to citizens of Aurora, but also places Aurora at a very negative position at the global level. The Council would like to seek your attention of the Honorable Lordships to the intent of the decision makers as well as the constitutional drafters for considering right to vote as a constitutional right. Your Lordship, I will take you to the era of late 1940s when the Constitution was getting drafted. Your Lordship, there is a book by B. Shiva Rao. The title of the book was The Framing of India's Constitution Select Documents, Volume 2. Your Lordship, the page 54 tells us Dr. B.R. Ambedkar and K.T. Shah proposed including right to vote as a fundamental right. The proposal, which was first passed by the two major subcommittees and also was endorsed into the primary report of the Constitution. Your Lordship, subsequently, I would also like to highlight the decision of our law, of the decision makers of our honorable courts while deciding whether the right to vote is a constitutional right or not. Your Lordships, it was the case of PUCL in the 2003, mentioned in the compendium, page 98. Your Lordship, in the conclusions of the para 123, Honorable Justice P. Venkataramana Reddy took the efforts to pen down that the right to vote pertaining to the elections of the House of People or Legislative Assembly is a constitutional right and not a merely statutory one. Your Lordship, the apex court in the state of in the case of Rajabala versus state of Haryana also affirmed that right to vote is a constitutional right. It believed that the right to vote is a constitutional right. Ultimately, after various interpretations and jurisprudence, it was in the year 2023, in the Anu Barnawal's case, mentioned on the page 19, para 401 of the submitted compendium, the apex court held in a constitutional bench with the majority that the right to vote is a constitutional right. Concurring to the opinion, Justice K.M. Joseph, who was leading the constitutional bench, went ahead and wrote down that that the right to vote is not only limited to Article 326, but flows through Article 15, 17, and 19 of the Constitution, 19 and 21 of the Constitution. Your Lordships, this brings the Council to its second limb of the argument that the declining of the right to vote is violation of the fundamental rights of the peoples of the residents of Aurora. Your Lordship, the Council would discuss the fundamental rights in the three manners. Firstly, Article 19, then Article 14, and then Article 21. Your Lordships, when we consider Article 19, casting a vote is not a mere exercise that is conducted in the state of Aurora after every 5 to 6 years. By the way, it is a political expression by which the voter's speech or expression in the case of election would include casting of vote. This is to say that the voter speaks out or expresses by casting of the votes. Your Lordship, the similar stance, so this stance was held in the by the Manipur High Court in the case of Anjan Sham Kumar, mentioned on the page 103, para 35 of the compendium submitted, from which we can understand that the courts are coming to a belief that casting a vote is a way by which voters expresses himself. The section 62(5) of the RPA directly infringes the right by denying under trials the ability to participate in the democratic process, despite them not being convicted of any crime. Your Lordships, coming to my second limb of Article 14. Your Lordship, jurisprudence of Article 14 is very vast. It took a very long time for our judiciary to reach to a firm conclusion. Finally, Your Lordship, in summing up Article 14, which guarantees the right to equality, stands out on two major points. Firstly, the law that makes a classification must be with intelligible differentia, and it should have the nexus with the statute. Your Lordships, also the law must not be arbitrary. Lordships, the object of section 62(5), being clear by the apex court, is to prevent the criminalization of politics and maintain the property of elections. But when it comes to under trial prisoners, shall they be considered in the same bracket of the convicted creates a lacking intelligible classification. As under trial prisoners who have not yet been convicted must be treated legally innocent. The principle of presumption of innocence is very deep rooted in our nation. Well, and so is in also the well-established criminal law that has been come into place. Rather, Your Lordship, the classification should be inside the prisons between the convicted and the under trials. Lordship, in the recent in 2024 only, in the Javed Ghulam Nabi's case, as my co-counsel also discussed, the para 20 of the case stands as a postulate of criminal jurisprudence that an accused is presumed to be innocent until declared guilty cannot be brushed off, howsoever stringent the penal code may be. Your Lordships, this makes the courts to think about whether the classification is valid or not. Your Lordships, coming to Article 21, it is humbly submitted that the right to what is right to dignity or right to life. Under Article 21, the apex court has melted down it for us that right to dignity is intrinsic to the right to life and includes the ability to exercise the agency and autonomy in one's decision. The blanket exclusion, Your Lordships, of the under trials from voting under section 62(5) arbitrarily curtails this liberty. It violates the right to dignity, which forms an essential component of Article 21, by assuming guilt without conviction and stripping them of their democratic voice. Your Lordships, hence the articles comprising 14, 19, and 21 form the golden triangle and confers right to vote a constitutional color that cannot be arbitrarily stripped out to the extent it applies to under trial prisoners, which stands in a clear violation of the constitutional safeguards. Your Lordships, while the section may serve a legitimate purpose, it's preventing convicted criminals from participating in elections. But its extension to under trials who are presumed innocent is arbitrary and unconstitutional. Therefore, the Honorable Court must strike down the application of 62(5) and restore the constitutional right to vote for the under trial prisoners. If Your Lordships don't have any further questions, the Council seeks the permission to recite the prayer.
Principal proportionality.
Yes, sir.
Go to issue number 3.
Yes, sir.
Judgment issue number 4.
Yes,
Right. How will you justify the statutory right to the constitutional right? You have referred for the principle of proportionality. You have mentioned Article 21.
Yes,
And its solution Article 14.
yes.
Isn't it? How will you justify under Article 19?
No, sir, I completely agree with your point, but the Council's arguments were completely based on Article 21 for the test of proportionality. It was for the fourth issue where the Council went on the arguing for 14, 19, and 21. And 21. Yes, Your Lordship. Yes, Your Lordship. If Your Lordships grant the permission, the Council seeks the permission to recite the prayer.
Rights of convicts, procreation.
Yes, yes, Your Lordship.
Provincially celebrated judgment.
Yes, yes, Your Lordships.
The rights for entry time and probably was a judgment of first of its kind.
First of its kind. Yes, yes, Your Lordship. You're well aware of that. Your Lordship, the Council recites the prayer. Wherefore, in the lights of the issues raised, arguments advanced, reasons given, and the authorities cited, it's most humbly prayed that it may be pleased to that the court may be pleased to declare that Section 45 of the PMLA, which imposes stringent conditions for a granting bail, violates the fundamental rights guaranteed under the Constitution of Aruba. Secondly, declare that the arrest of Dr. Jeremy Comte was unconstitutional due to failure of providing the written grounds of arrest. Thirdly, declare that the timing, need, and the manner of arrest of Dr. Comte violates the principle of proportionality as interpreted by Article 21 of the Constitution of Aruba, and is seen as a violation of right to free and fair elections under the constitutional framework. And lastly, your lordships, declare the section 62(5) of the Representation of the People Act 1951 as unconstitutional to the extent that it bars the under trial prisoners from the right to vote. And pass any other order discretion that the direction that the Honorable Court may be pleased to grant in the interest of justice, equity, and good conscience. All which is respectfully submitted. And for this act of kindness, the petitioner's duty bound shall ever be. Your lordships, it was pleasure arguing before the Honorable. Thank you.
The council seeks permission to begin. Greetings to the bench. May it please the Honorable Court. This is Counsel 1 appearing on behalf of the respondent in the present matter. Your Lordship, I shall be dealing with issues 1 and 4, while my co-counsel shall be dealing with issues 2 and 3 in the present matter. Issues 1 and 4 deal with the constitutional validity of Section 45 of the Prevention of Money Laundering Act and Section 62 subclause 5 of the Representations of People's Act 1951. I shall be taking quotes 30 minutes of the time, while my co-counsel shall be taking 24 minutes of the time, and we have reserved 3 minutes as a rebuttal time. In the present matter between Liberty Matters and the state of Nirvana, the respondent submits that Section 45 of the Prevention of Money Laundering Act 2002 imposes twin conditions for granting bail in money laundering offences post the amendment of 2018, wherein the language of the clause was modified only to apply the offences of money laundering to the bail condition, is constitutionally valid in nature. The Supreme Court had revisited the same in the case of Vijay Madanlal Chaudhary versus the Union of India, wherein the constitutional validity of Section 45 was upheld by observing that said section is applied judicially rather than arbitrarily in nature. Moreover, the said section doesn't put an absolute restraint in granting the bail condition. Thus, withstanding the findings of Vijay Madanlal Chaudhary, the respondent contends that the defects which were dealt in the case of Nikesh Tanachand, which overturned and which said that Section 45 is unconstitutional in nature, have been adequately measured post the amendment of 2018, as well as in the case of Vijay Madanlal Chaudhary. Therefore, the respondent contends that Section 45 is reasonably related to the intended objective of the PMLA and is non-violative in nature. Moreover, the current writ petition, which is filed under Article 226 of the Constitution of Aurora by Liberty Matters, a civil liberty organization, should be dismissed because Liberty Matters lacks the locus standi as it's not the party affected in the present case. With your permission of the Lordship, I shall be moving into my first contention, which deals with the reasonable classification being followed in the Section 45. I shall be relying upon Article 14 of the Constitution of Aurora, which deals with the intelligible differentia and the rational nexus, a twofold test which has been held in the case of Anwar Ali Sarkar versus the state of West Bengal. With your permission, may I begin with the argument? Much obliged, Your Lordship. I request Your Lordship to refer to cardinal page number 3 of point B in the respondent's memorial for the same. Are all of the lordships with me? Much obliged, your lordship. Your lordship, all is point B on cardinal page number 3. Much obliged, your lordship. In contrast to what the petitioners stated and have contended in their oral arguments as well as in their written arguments, they have relied upon and made and created an ambiguity in the term of offense of murder and in the offense of money laundering. What the respondent is trying to contend here is the crime of murder can be committed impulsively or in the heat of a moment. However, economic offense of money laundering is very well calculated and deliberate with the main aim of personal profit and personal gain. Given the nature of such economic offences and the allegation of Dr. Kong committing the offence of money laundering through the Hawala transaction amounting of 5 billion rupees in order to finance his election campaign has not only affected the citizens of Nirvana, wherein this election campaign was originated, but also to the neighboring country's citizens of Westeria. Thus, this includes the gravity of the economic offence of money laundering much higher. Therefore, this justifies a distinct and a more stringent approach of bail as a reasonable classification. The respondent would like to highlight the case of Allahabad High Court in the case of Anirudh Kamal Chopra, which observed that money laundering poses a serious threat to the national interest of the country, often involving offenders who occupy such entrenched position in society which are difficult to prosecute and difficult to find as such cases. Such, given the nature of the money laundering offences, moreover which involve such intricate conspiracy, the respondent submits that the reverse principle of jail is the rule and bail is the exception should be applied here. This reflects a need for a more rigorous standard in granting bail for money laundering offences, acknowledging the offences' far-reaching consequences and the challenging of bringing the offenders to justice. Now, Prevention of Money Laundering Act is a complete code in itself. It's a special offense which deals with economic offenses, which provides adequate safeguards to address the social menace. Now, the high arrest threshold has been mentioned under Section 19 of the PMLA. Now, this high arrest threshold justifies the high bail provision under Section 45. The respondent submits that the complex nature of the money laundering requires a stringent approach to prevent absconding and witness tampering. The substantial risk that the accused will commit the same economic offence again once released on bail is very important and crucial in understanding that the bail must be granted judicially on the application of the twin conditions itself, especially when the national security is at stake. This classification of the offence based on public policy and the underlying purpose of the act cannot be said to be arbitrary in nature. The Parliament is completely competent to legislate distinct procedure for special offences, which in this context are completely reasonable. Therefore, the twin conditions under Section 45 have rational nexus with PMLA's objective of deterring the money laundering. Therefore, these conditions are completely valid in nature and does not violate Article 14. Moving on to my second contention, I shall be dealing with the role of presumptions. Now, I have divided this argument in 3 different blocks. Firstly, the reverse burden of proof. Secondly, the onus to prove innocence initially lies on the prosecution. And thirdly, the presumption of innocence. I request your lordship to refer to point C on page number 5 of the respondent's memo. Are all of the lordships with me? Much obliged, your lordship. The first prong deals with the reverse burden of proof during bail application. The respondent contends that Supreme Court has upheld provision in varying bail application. In the case of Rohit Tandon versus the Directorate of Enforcement, it was observed that Section 24 of the PMLA, unless proven otherwise, the court and the authority shall presume that the proceeds of crime are that of the money laundering, and the burden of proving its denial lies with the appellant. Moreover, the petitioner have already stated in their submission that they have already agreed that the reverse burden of proof applies for the economic offences of money laundering. Thus, even if the allegations are not fully substantiated, once a prima facie case has been established, the burden shifts on the accused under Section 24 of the PMLA to prove that the funds in question are not the proceeds of crime and remain untaken. This leads to the second prong of the argument, which deals with the onus to prove innocence on the grounds of twin condition on the accused arises only after the foundational facts have been relied upon by the prosecution. Now, in the current scenario, in the present case, as mentioned in paragraph R of the Moot proposition, Dr. Jeremy Comp needs to satisfy the twin condition in order to receive an bail before this honorable High Court. This scenario has arisen only after the prosecution has established foundational facts to dislodge the presumption of innocence. Moreover, the investigation which was conducted preliminary found out that Dr. Comp is involved in the proceeds of crime, which is of money laundering, in order to defraud the citizens of Nirvana as well as Australia, thereby generating the proceeds of crime which have been mentioned in paragraph L of the Moot proposition. Accordingly, what the respondent is trying to submit here is that the initial burden of proof actually lies on the prosecution, which must establish the relevant reasons in order to oppose the bail PA. Once this relevant reason, the opposition of bail PA has been established, only then the accused needs to satisfy the twin condition. Hence, the argument which was raised by the petitioner contending the presumption of innocence is completely invalid in nature. Now, this leads to my third prong, which deals with the presumption of innocence. Presumption of innocence is foundational in criminal jurisprudence and is well protected under Article 21. However, the presumptions with respect to the twin condition are with respect to the presumption of evidence and do not conflict with the presumption of innocence protected under Article 21. While the presumption of innocence wants the prosecution to prove the accused's guilt beyond a reasonable doubt, the nature, the seriousness, and the gravity of the economic offense of money laundering limits this presumption of innocence. Now, this has been established in the case of Krishna Janardhan Bhatt versus Dattacharya G. Hegde, which is a 2008 judgment. The departure from the traditional rule relating to the burden of proof is imperative. Without this, it would create an undue benefit and disappropriate benefit on the accused who do not need to prove anything, but just an undue benefit, undue burden on the prosecution to prove the innocence of somebody else. Therefore, the PMLA, which is aimed at countering social menace, aimed at combating the money laundering, justifiably deviates from the conventional burden of proof. I would like to cite the judgment of Moot of the Honorable Supreme Court, wherein the court upheld that the constitutionality of similar provision in NDPS, confirming that the rebuttal presumption is constitutional as long as the accused has given the right to disapprove it through the evidence. This shift underscores that the presumption of innocence is not a guarantee, especially when significant societal harm is at stake. Therefore, the respondent argues that the twin conditions in the PMLA, which incorporate the reverse burden of proof, do not violate Article 21. These provisions, as upheld in various judicial precedents, are rules of evidence specifically designed to address grave societal harm. These conditions align with the established legal principle by addressing severe societal harm and providing the accused a fair opportunity to rebut the presumption in proving the twin condition, thus upholding the process through due fairness. Therefore, Section 45 of the Prevention of Money Laundering Act 2002 is said to be completely constitutionally valid. With the permission of your lordship, may I move on to my second issue, which is issue 4, which deals with Section 62(5) of the Representation of People Act and its constitutional validity. Much obliged, your lordship. In the present matter, the present issue examines a suo motu matter taken up by this very court to determine whether Section 62(5) of the Representations of People Act 1951, bearing the prisoner's right to vote, is well within the constitutional scheme. the respondent submits Dr. Jeremy Com, currently and under trial in lawful custody, sought interim relief from the High Court of Nirvana to exercise his voting rights in the upcoming state elections as mentioned in paragraph W of the Moot proposition. His arrest on the charges of money laundering and the postponement of the bail due to the tense political climate and the concerns over the public safety and national security. Now, his right to vote is denied as per section 62(5), which mandates that any person who is confined to prison, whether serving a sentence of imprisonment or transportation on his conviction for any offence, and under trial, which is very much relevant in this present case, or in lawful custody of police for any reason, is deprived the right to vote in the election. The respondent contends that the denial of Dr. Com's right to vote is completely valid as the said right is a statutory right and is not absolute in nature. Moreover, the Supreme Court in the judgment of Anupul Chandra Pradhan has held section 62(5) to be constitutionally valid in nature as the right to vote is subject to certain limitations, being a statutory right and this limitation are applied via the statute itself. Thus, the respondent contends section 62(5) of being non-violative of Article 14, 19 and Article 21, which the respondent shall be proving in two different contentions individually. The first, apologies, Your Lordship. The first contention deals with section 62 subclause 5 of the Representation of People's Act, qualifying the doctrine of reasonable classification. I request Your Lordship to refer to point A on page number 17 of the respondent's memory. Are all the Lordships with me? Much obliged, Your Lordship. The respondent submits that section 62(5) of the Representation of the People Act makes a distinction between prisoners and non-prisoners, thereby creating a classification on the basis of a confinement status of an individual. Now, the respondent says that this classification is completely reasonable and intelligible because it isolates an individual who are denied a consequence as of an alleged criminal behavior and confines them in a manner that reasonably restricts their right. Moreover, this section is complete in line with the legislative objective. The Honorable judgment. I request Your Lordship to refer to page 287 of the compendium for the same. The page number is mentioned in the top right corner of the compendium. For Your Lordship, the respondent's compendium. The said judgment, which is Anupul Chandra Pradhan, the Supreme Court has held that such a distinction supports the state's goal of preventing criminalization of politics and ensuring that the integrity of the democratic, free and fair elections have been met. Now, allowing an individual with alleged criminal background to vote affects and subverts the legislative intent, which is to uphold the sanctity and the integrity of the democratic election. The court has emphasized the Constitution's main objective is to conduct free and fair election, which have been rightly met with respect to section 62(5) of the RPI. Therefore, the respondent submits that the restriction imposed by this section is a reasonable classification, meeting the test of intelligible differential and rational nexus, part of Article 14, and is completely constitutional in nature. This leads to a second prong of the argument, which deals with the second contention. The respondent submits the section to be non-violative of the fundamental rights protected under Article 19, 1A and 21 of the Constitution. I request Your Lordship to refer to point B on cardinal page number 18 of the respondent's memorial for the same. As are Your Lordships with me? Much obliged. As mentioned earlier, Dr. Kong was arrested for the allegations of money laundering, which impacts his national interest and is very grave in nature. Now, a person in prison is as a result of his own conduct and is therefore deprived of his liberty during the period of his imprisonment and cannot claim an equal freedom of movement, speech and expression as others who are not in prison. It is additionally submitted that right to vote is expressly different from freedom to vote. The former is a statutory right, while the latter is actually a phase of freedom of expression protected under Article 19(1)(a) of the Constitution. Thus, the restriction which is imposed on Dr. Jeremy Combs as a statutory right to vote does not violate the right to freedom of speech and expression, as the right to franchise is not protected under Article 19(1)(a). In contrast, moreover, the respondent submits that the legislature chooses not to confer this right to restrain, which basically means the under trial. The question of restricting their freedom of voting does not even arise. The freedom of voting comes into attention only after the statutory right to vote is granted. If under trial are excluded from the voting process under Section 62(5) of their 62(5), their freedom to vote is not restricted. It simply does not exist, and therefore it does not violate Article 19(1)(a). Moreover, without the prejudice of what I stated above, Article 19 subclause 2 mentions certain reasonable restrictions pertaining to Article 19(1)(a). The restriction imposed in order to protect the national security and the public order is intended to prevent the criminal influence in the electoral system, thus justifying its restriction under Article 19 subclause 2. The respondent humbly submits that the restriction to the right to franchise aims to serve a larger public interest by preventing electoral interference from incarcerated individuals and thereby preserve the probity of the democratic process to ensure free and fair elections. The test of proportionality suggests that any restriction on the right under Article 21 must be reasonable and secondly must be probable to the perceived threat. This has been seen in the judgment of modern dental college. In the instant case, the restriction is in conformity with the principle of proportionality since the restriction imposed is reasonable and profound to the perceived threat of sanctity of the election. Furthermore, allowing an under trial to vote leads to equal rights between a normal citizen and an accused whose bail application or even a trial application is yet to be heard. Now, this can result in allowing them to vote. This can result a wrong candidate being chosen, leading to the criminalization of politics, which cannot happen as the legislative intent is to prevent the same and to ensure the free and fair election take place. Therefore, the restriction imposed under Section 62(5) of the Representation of People's Act is not in violation to Article 19(1)(a) and 21 of the Constitution and cannot be said to be unconstitutional in nature as it is banned in law and upholds the objective of ensuring free and fair election, a cornerstone of democracy, which is the basic feature of the Constitution. Yes, Sir Lordship. Yes.
This issue. Especially so this is constitution that we cannot be taken away. Probably thereafter King Joseph Chairman is also there.
Your Lordship, what I'm trying to contend here is that what the respondent also highlighted on the People's Union Civil Liberty Organization judgment of
law is that criminals should be there should be some mechanism where criminals are debarred from contesting election. It's another that's a whole different story.
completely understand.
Probably they set a law on that purpose. Or whether you can take over the right to vote. That issue has been brought up since 2003. This People's Union Civil Liberty and there is another General Justice P.M. Joseph.
Your Lordship, the respondent relied on the judgment of People's Union of Civil Liberties of 2013, which has overturned the judgment of 2003. In the 2013 judgment, the distinction has been made on the basis of right to vote and freedom to vote, wherein it has been completely said that the right to vote being a statutory right, but the freedom to vote being a constitutional right. Now, in the present scenario, Section 62(5) the restriction of the right to vote, which is a statutory right. Hence, it leads to no violations of violations of
2003, right to vote has been recognized because the constitutional right. And if there is one that they say there are two accused. One gets bail, another doesn't get bail. He on account of his being a large one will be entitled to cast vote. And what about the person who on one reason or other on account of stringent conditions of act under which he has been booked may not be able to cast vote? That itself is a ground.
Your Lordship, the bench needs to understand that he's still an under trial. The result of the bail or even the trial can go two ways. Either he's innocent
Yes.
or either he's guilty. One needs to understand that it's impossible to make a difference on the basis of the under trial or whether either he or she is guilty or innocent. And hence,
That's
it's
why
better to
amendment
have
is- That's why amendment is made in People's Representative Act. That for such and such, if you are convicted for 2 years, less than 2 years, you may be able to contest election.
Yes.
Or you may be able to, because otherwise, suppose he's convicted in one court, appeal is pending for more than 20 years. What about his rights?
Yeah, that your Lordship, the council completely understand now that is section 8 subclause 3, which deals with the contesting of the election. However, the right to vote is a very important right wherein one elects a person who completely controls the country. Now that now it's impossible to make a differentiation between an under trial being innocent or actually being guilty. Hence, it is better a uniform application is applied wherein all the under trials are not allowed to vote, which they will not create any unjust.
Cardinal principle of criminal jurisprudential presumption of innocence. Till the time one is not held guilty, is deemed to be innocent. That's why if you are convicted, even then, your right to vote cannot be curtailed. That has been held now.
Your Lordship, if you have any further questions with respect to issue 1 and 4, I'll be happy to deal with.
On one side, we have studied that it is economical. Dr. Comte has considered economic. On the other hand, Lord's stated that there is must be some reasonable classification. How you correlate with this, with the present case with regard to Dr. Comte and national security? Because you have also said that if economic offense, if we create a national, whether it is a national security case or it is a economic offense, and what is the reasonable
Because
classification?
every economic case cannot be linked with national security.
Completely
Otherwise, day in, day out, if you see NPAs, amounts are being declared NPAs. Number of your victims, after having usurped the money, they are just ran away from this country. If somebody for A reason or B reason is unable to repay the loan, though it falls under the economic, because it would affect the economy of the country. It may not fall in the economic crime, but ultimately the argument, if we permit you to raise that this is economic crime, because all cases public this Prevention of Money Laundering Act, an account of this money laundering, ultimately government is put to loss, and then you would try to build up a case. That's this issue related to the national security. Is it your case that every case under PMLA is linked to the national security?
Your Lordship, if you see the offense of money laundering involves the money of not only the one particular state, but involves the money of the entire nation. Even if it being a very reasonable or very small amount, or even if being a big amount, at the end of the day, the national interest of a particular country is being affected. One needs to understand that any offense of money laundering is grave as the legislation needs to take small steps. Even in the case of small offenses or small amount of money laundering, and only in that way one will be able to achieve the objective of the PMLA, which is to combat the money laundering. Moreover, if your lordships are satisfied,
No question.
Yes, yes.
The question of presumption of innocence.
yes,
Issue number one, your argument is about the presumption of guilt.
Yes.
Right? How will you justify it in fair trial? You know, 10 scoundrels in a state but from innocent will not be getting accused to lose. How will you justify?
your lordship, with respect to the Prevention of Money Laundering Act, what the petitioners have stated that the presumption of innocence is being violated. What the respondent states, as per section 45(1), it's on actually the burden of proof is on the prosecution to firstly lay out the foundational facts of the case. Once the prosecution has laid down the foundational facts of the case, the prosecution is given an opportunity to oppose the bail plea. This indirectly shows that indirectly gives the reasoning of why the prosecution doesn't believe that the
Based on the facts or the three conditions.
this is with respect to the twin conditions of the section 45. Section 45(1) says that the prosecution is given an opportunity to oppose the bail plea. Now, section 45(2) states that if the bail plea has been opposed, then only the accused has to satisfy the twin condition. Hence, the presumption of innocence question doesn't even arise, because initially it's actually on the prosecution to prove that prove that the bail application is opposed, and only then the accused will have to satisfy the twin condition. If your lordship has any further
information. So part of section 45, we need to understand. This is when this has been made by an honorable apex court. When this has been cases, we need to certain whether whether bail can be granted under section 45 and European settlement. The three conditions are taken. But if you read section 45, probably doesn't lay any bar. Court can go accept the parameter in section 37.
Yes,
Court
completely.
at that stage is to see, evaluate the material used on record by prosecution.
Completely. Then it's not a stringent condition, and it should be applied to the condition of money laundering. Has your lordship just have any further questions? Thank you so much, your lordship. It was an honor to argue before this bench. My co-counsel shall be dealing with issues 2 and 3. Thank you so much, your lordship.
May it please this honorable bench, I am counsel to appearing for the respondents, and I shall be dealing with the second and third issues at hand, which is with respect to Dr. Kong's arrest not being unconstitutional and arbitrary, and it was conducted in accordance with the procedure mandated by law, and that the timing, manner, and need of Dr. Kong's arrest is not in violation with the doctrine of proportionality or the fundamental rights guaranteed to him under the Constitution are not being violated in the present case. I shall be taking a total of 24 minutes of the court. With respect to the second issue, your lordship may find it on cardinal page number 8 of the respondent's memorial for your lordship's perusal. Page number 8, your lordship, of the respondent's memorial.
Yes.
Much obliged, your lordship. I shall be dealing with the same under 3 prongs. My first prong shall deal with the due compliance with the procedure under section 47 subclause 1 of the Aurora Nagarik Suraksha Sanhita or ANSS, read with section 19 of the PIA. The second prong shall be dealing with the due compliance exhibited by the respondent with respect to sections 36 subclause B and C of the ANSS and section 48 of the ANSS. And lastly, my third prong shall satisfy on the aspect of concurrence with the legislation as mandated in Article 22, subsection 1 of the Constitution. With your lordship's permission, the council would now like to begin. Much obliged, your lordship. Your lordship, it is the most humble contention of the respondents that section 47, subclause 1 of the Aurora Nagarik Suraksha Sanhita states that the concerned officer must communicate the grounds of arrest to the arrestee and does not mention the term written anywhere in the legislation. And furthermore, as per paragraph S of the Moot proposition, the reasons for arrest were duly provided to Dr. Kong in the present manner, and the same were given to him and communicated to him via the arrest memorandum as well. And it was not the case that he was totally oblivious of the grounds of his arrest. Furthermore, it was held by the Honorable Bombay High Court in the case of Sunil Chenini that the important aspect is that the grounds of arrest are communicated to the arrestee, and that it is said to be discharged if it is done with reasonable dispatch, the way it was done in the present case with respect to Dr. Kong. Secondly, after the perusal of section 19 subclause 1 of the PMLA, we humbly contend that it does not mandatorily or necessarily state that the grounds of arrest are to be provided in writing, and it prescribes the term informing the arrestee of the grounds of such an arrest.
Moreover, it was held by the Honorable Delhi High Court in the case of Moin Akhtar Qureshi, as mentioned in paragraph 279 of the compendium submitted by the respondent, that oral communication of the grounds of arrest is not only a substantial but a proper compliance with the particular provision. The respondent furthermore respectfully submits that section 90. The respondent respectfully submits that section 19 subclause 3 of the PMLA was duly adhered by the Directorate of Financial Integrity, that is the DFI, as Mr. Kong was brought before the remand court within a span of 24 hours, as mentioned in paragraph N of the Moot proposition and also in clarification number 27 to the Moot proposition. Additionally, we would like to bring this to the bench's attention that if we assume that the grounds of arrest were not communicated to Dr. Kong orally or via the arrest memorandum, which bears his signature as evident in Annexure 2 of the Moot proposition, then he had been given ample opportunities to bring this very grievance before the remand court, had it been the case that the proper compliance or proper procedure with respect to his arrest was not done in a proper manner, and we have been prejudiced in any manner. This therefore puts a question mark on the credibility of the appellant's intentions with respect to this very application. Now, coming on to the second prong of my argument, which is with respect to section 36, subclause B and C of the ANSS, it states and in totality elucidates the fact that while a memorandum of arrest is prepared, it needs to be countersigned by the arrestee, and the news of the arrest should be communicated duly to the personnel of the arrestee, preferably a close family member. While section 48 of the ANSS entails the obligations of the investigating officer, that is to inform about the arrest, the manner of the arrest, the particulars of the arrest, and all these other details to the arrestee as well as to the concerned relative of the arrest. And the same had been upheld by the Apex Court in the case of Joginder Kumar versus the state of UP and T.K. Basu versus the state of West Bengal. Your Lordship, in the present case, the DFI had punctually informed the reasons of his arrest to Dr. Kong's spouse, as mentioned in paragraph N of the Moot proposition, and the same was elucidated and included in the arrest memorandum, which was countersigned. I highlight again, countersigned by the arrestee himself, as evident in the arrest memorandum as provided in Annexure 2 of the Moot proposition. Therefore, it is apparent that the DFI did not blindside Dr. Kong and that no prejudice whatsoever was caused to him in the present case. Coming on to the third prong of my argument, Your Lordship, Article 22, subsection 1 of the Constitution provides that inter alia, no individual who is arrested shall be detained in custody without being informed of the grounds of such an arrest. And the rationale behind the same is that the arrestee is able to remove any sort of mistake, misapprehension, or misunderstanding with respect in the mind of the arresting authority and is aware of the reasons for his arrest. The latter part of this I've already dealt with before in my second prong. So the respondent hence contends that the appellant was in fact informed of his grounds of arrest and was also rightly given the right to have a legal counsel, have him represent in the remand court, which is additionally a due compliance under the measures mandated in Article 22, subsection 2 of the Constitution. Moreover, the appellant may contend that Articles 22, subsection 1 and 22, subsection 5, when read together, clearly state that it is that the written grounds of arrest have to be provided. However, the latter is purely regarding preventive detention, and it was held in the case of Moin Akhtar Qureshi that the safeguards mandated in both of these provisions should not be read or interpreted together, given the extent of these safeguards when in consonance with the arrest of preventive detention. And moreover, the usage of the term inform and communicate have to be viewed in context in which they have been used. Hence, it is the most reverent contention of the respondent that the arrest of Dr. Kong was not conducted in a forced manner, and that it was in fact conducted in a way that was consistent and in accordance with the procedure mandated by law. Now, with your Lordship's permission, the Council seeks to address the third issue at hand, which is with respect to the timing, manner, and need of Dr. Kong's arrest not being violative of the doctrine of proportionality.
So the argument, the solution of yours.
Yes, Your Lordship.
There is no requirement to give reasoning rightly. That's so first of all.
Indeed, Your Lordship.
You say that it can be orally said that for such and such you are being arrested.
Your Lordship.
Because law says, you said that treason of law
Indeed,
is
Your
read
Lordship.
as it is.
Indeed, Your Lordship.
Is there any law? Can you find out any law?
Yes, Your Lordship. So certainly, if my laws would refer
You can number of judges. Indeed,
Indeed,
that law is to be read in context in which it is mentioned.
Indeed, Your Lordship.
But only there is number of judgments on this,
Indeed, Your Lordship.
which may be against you.
Indeed, Your Lordship.
Have you gone through those judgments also?
Indeed, I have, Your Lordship. But in the present case, there has to be a little
You got it
interpretation.
also.
Little interpretation of the statute as mandated in legislation. It clearly states, does not mention the term written anywhere. So primarily, it was not the case that the grounds of arrest were not given to him only. He was apprised of the grounds of his arrest. He was given the reasons of his arrest in the arrest memorandum, and he has countersigned the same, saying that yes, I have been given the grounds of arrest. So it was not that he was blindsided or he was prejudiced and he didn't know what the reasons for his arrest were. That is primarily what the respondent's contention is an issue to.
You need to say that only by apprising of reasons,
Indeed, Your Lordship.
that is sufficient compliance with that provision of law. At that stage, you need not have made the available objective material which you would subsequently place before court.
Yes, Your Lordship. So that point of evidence and sufficient reason to believe, as Your Lordship had earlier mentioned with respect to my opposing counsel, I'll be mentioning that in issue 3. So I'm dealing with it in depth.
But then how did you determine the principle of proportionality?
Your Lordship. Yes, Your Lordship. So, Your Lordship, I'll be taking my lords to the 4-pronged test of proportionality, which was held by the Apex Court in the case of Modern Dental College, and how all the 4 provisions were duly complied by the respondents in the present case, and how, given the severity of the offence, that is PML in this present case, how that violation is somewhat outweighed by the interest of public, which is the reasonable restrictions that we're talking about. So, I'll be mentioning all of these small contentions in my major arguments. With Your Lordship's permission, I would like to now continue with issue 3. Much obliged, Your Lordship. Your Lordship, I shall be dealing the third issue under 3 prongs. Firstly, I shall be explaining, my lords, about the doctrine of proportionality and Article 21's compliance. Secondly, I shall be bringing this before the court's attention, how the procedure established by law under Section 19 of the PMLA, the reason to believe aspect, is being satisfied. And lastly, I shall be focusing on how the same process was not in violation to the right to free and fair election. So, Your Lordship, Article 21 of the Constitution states in verbatim that no person shall be deprived of his life or personal liberty except according to procedure established by law. The scope and ambit of Article 21 has been evolving over decades, and the same is subject to reasonable restrictions provided they are in accordance with the principles of reasonableness and proportionality. Now, in this, I would like to bring my lord's attention to page 282 of the Respondent's Compendium, wherein the Apex Court had elucidated in the case of Modern Dental College the 4-pronged test of proportionality that needs to be satisfied while imposing a restriction. I would like to mention again page 282 of the Respondent's Compendium. Am I not with me? Much obliged. Your Lordship, the 4 prongs are that 1, it is designated for a specific purpose. Number 2, the measures undertaken to effectuate such a limitation are rationally connected and are in consonance with the fulfillment of that particular purpose. Number 3, the measures undertaken are necessary and are inexhaustive. And lastly, proportionality strictly sensu. Your Lordship, before I come on to all these prongs in detail, I would like to mention that the statement of objects and reasons to PMLA recognizes that money laundering is a very severe offence, and it poses a severe and serious threat not only to the financial systems of countries but even to the financial integrity and sovereignty of that nation. Given the deep-seated conspiracies and the substantial public fund losses that are inherent in economic offences, the arrest in the present case was a necessary measure to further safeguard the integrity of the integrity and stability of the citizens of Aurora as well as of Wisteria. Moreover, the respondent contends that Dr. Count is a politically influential figure, given the fact that he holds the office as the Chief Minister of Nirvana, and given the prowess he holds as the Chief Minister, and he is in a position to interfere with the investigation by tampering with evidence and can easily sway away the witnesses. His arrest is therefore the least restrictive measure available for the protection of public interest, considering the severity of the offence, the potential influence of the accused, and the limited alternatives to ensure non-interference in this investigation. And ultimately, the 4th principle of proportionality, that is the proportionality strictu sensu, basically demands striking a balance between the societal relevance of restricting constitutional rights and the significance of accomplishing justifiable state goals. Hence, the violation of Dr. Com's right under Article 21 is outweighed by the public interest in safeguarding public money, in upholding financial integrity, and guaranteeing a free and fair electoral process. Now, with respect to the second prong of my argument, I would like to bring your lordship's attention to the due compliance exhibited by the respondent with the procedure established by law under section 19 of the PMLA. After a clear perusal of section 19 of the PMLA, and the same is elucidated in point A subclause 2 on cardinal page number 13 of the respondent's memorial, it states the power of an authorized officer to arrest a person, and additionally, the arrestee must be informed of the grounds of such an arrest. Firstly, coming on to the material positions that lead to that reason of belief. So, in the present case, the complaint that was filed by Mr. Robin Hood Spencer, which is attested as Annexure 1 of the Moot proposition, subsequently, the FIR that was lodged filed by the NBI, as mentioned in para L of the Moot proposition, serves sufficient proof and material in order to justify his arrest. Even the ECIR, Enforcement Case Information Report, was duly lodged by the TFI, and as contended by my opposing counsel that it had not been furnished, it was held by the apex court in the case of Vijay Madandal Chaudhary that it is not mandatory to furnish a copy of the ECR to the accused, and the same can be furnished later upon. However, on record, it has been brought. So, para N of the Moot proposition mentions the fact that the investigation conducted by the DFI prima facie found that Dr. Com generated illegal proceeds through these activities, which routed around 5 billion rupees through the Havara system, and which was eventually used by him to fund his election campaign in Nirvana. And hence, it can be inferred that these findings substantiate the reasons to believe as mandated in Section 19 of the PMLA. And moreover, this reason to believe was duly, again, as I mentioned in issue 2, was duly informed to Dr. Com via the arrest memorandum as well. And the same had been furnished to him in all manners possible. Now, coming on to the third prong of my contention, which is with respect to the right to free and fair electoral process. Your Lordship, Article 19, subclause 1, G of the Constitution recognizes the right to practice any profession or trade. However, the same is subject to reasonable restrictions as enshrined in Article 19, subclause 6 of the Constitution. And in the present case, the same is restricted on the grounds of public interest. As I've mentioned again and again, that the necessity and the timing of arrest of Dr. Com is consistent with the reasonable restrictions outlined under Article 19, subclause 6, and the same is justified due to the severity of the allegations of financial crime, including the offence of money laundering. And therefore, the arrest was in furtherance of a compelling interest in ensuring that the elections are conducted fairly and without any undue influence of illicit activities that were aimed to prevent any potential misuse of power or undue influence that could undermine the democratic process. Moreover, I would like to bring this to the bench's attention that my opposing counsel had mentioned that there was a press note that was released by the DFI in the present case. So, Your Lordship, the reason why it was released in the present case was in furtherance of mandating and having free and fair elections. Because, first and foremost, as I mentioned earlier, Dr. Com was a highly influential figure. Secondly, it is a governmental agency which comes under the central government, and it is in order to maintain transparency and accountability with its citizens, the press note was mandatory. And thirdly, the necessity and the timing of releasing that press note was important because it was during the electoral process. And rightly, the voters should be aware of what investigation is going on against Dr. Com, who is a contender in those very electoral processes. Therefore, I would like to conclude that the nature of the measures taken by the respondent is not violative and in furtherance of the right to free and fair elections guaranteed under the Constitution. Therefore, it is the most humble contention of the respondent that the arrest procedure undertaken by the DFI is in consonance with the procedure established by law, and no prejudice whatsoever was caused to Dr. Com in the present. Now, if you all also have any questions, I would like to happily answer.
Very simple, but I could understand. Only under what circumstances, for what reasons, your constitutional rights or fundamental rights can be curtailed.
Indeed, Your Lordship.
So principles have to be later.
Indeed, Your Lordship.
But you think that these principles can be made applicable in each and every case? Won't it vary in each case? Especially if you read this modern dental college, condition number 4.
Proportionality is strictly sensitive. Yes, Your Lordship.
Because that may vary from case to case.
Indeed, Your Lordship.
Here, public proposition was that one such and such institution wanted to set up some medical college,
Yes, Your Lordship.
claiming that's my right.
Yes, Your Lordship.
Yes, it is your right, but subject to these conditions.
Indeed, Your Lordship.
But here, how to say that instinctive sensitive would apply to the case of Dr. Comet also. Yes, where question of civil liberty is involved.
Indeed, Your Lordship. Your Lordship, so first and foremost, issue 3 primarily deals with how his arrest was unconstitutional and was against the test of proportionality as mandated in Article 21. As I've already satisfied Your Lordship on the fact that Article 21, it reads like the Article 21, the legislation reads that no person shall be deprived of his life or personal liberty except according to procedure established by law, and if the same is subject to reasonable restrictions. If I may continue, yes. The same is subject to reasonable restrictions and provided they are in accordance with the principle of reasonableness and proportionality. Now, the fourth prong of the four-prong test of proportionality, the stricto sensu principle basically demands striking a balance in the societal relevance of restricting those constitutional rights and the significance of accomplishing justifiable state goals. Now, in the present case, the offense which we are dealing with and which Dr. Com has been the reason for his arrest was with respect to the severe offense of money laundering and how it was affecting not only the citizens of Aurora but even the citizens of West area, given the complaint was given by a West Indian citizen. Hence, it is something, hence his right under Article 21 is outweighed by the public interest in safeguarding public money and upholding financial integrity. Hence, in the present case, that's how.
Because in that case, you can argue that only alternative available was that.
Indeed, Your Lordship.
Because he was in higher position.
Indeed, Your Lordship.
He could prevail upon.
Indeed, Your
He would
Lordship.
have influence the investigating agencies.
Very true.
He was in control of things.
Indeed, Your Lordship.
Before you could present challan or before you could present from remand, you could have managed something.
Indeed, Your Lordship. That is primarily what the intention of the respondent is. Beautifully put by Your Lordship. If any other further questions by my lord, I will.
Not part of the
Yes, Your Lordship. Yes, Your Lordship.
not specifically contending for the bench.
Yes, Your
That
Lordship.
it is not mandated. The information to be active with regard to the.
Yes,
That's the first part of the. Whether it is not violation of constitution.
I am sorry, I didn't understand Your Lordship's.
You have contended before the bench
Yes, Your Lordship.
that the information with regard to that is not sensitive. Section 36.
Yes, Your Lordship. Yes, Your Lordship.
Whether it is not a violation of constitutional provision, but was intended when you.
No, Your Lordship. So, Your Lordship, I think I lost your laws while I was explaining the same. Your Lordship, Section 36, subclause B and C of the ANSS talk about the memorandum of arrest being prepared and how those information regarding the arrest needs to be given to the arrestee and his close relative. In the present case, we are contending that yes, we have given the information regarding your arrest, regarding the manner of your arrest, and regarding the reasons for your arrest, which is given in para N of the Moot proposition and even in the arrest memorandum. What we are contending is that your entire arrest cannot be declared as unconstitutional purely because written grounds were not provided to you. So in the present case, we are not saying that the arrest, given the, we should not be.
After this argument, run counter to earlier argument. Once you're saying that we had given memorandum
Yes,
citing the reason for arrest,
yes, Your Lordship.
but in same breath now you're claiming we have not given him any reason in writing for that. Once you have given him memo, you must have given some reason. For what reason you are arresting him?
Your Lordship, in the Moot proposition, the arrest memorandum is talking about the reasons for arrest. And in writing, if from what my preliminary understanding is after reading Praveen Kurkhaya and Pankaj Bansal, that there's a separate document which contains the written grounds of arrest. That is primarily what the opposing counsel is contending as well. So, yes, Your Lordship. If any other further questions, my lords, I'll be happy.
When spoke about the reverse burden
Yes, Your Lordship.
and also relied upon Murana chapter.
Yes, Your Lordship.
We would like to know at what stage this reverse burden would come in, whether at the stage of bail or at the stage of trial.
It's very pertinent question.
Your Lordship, it will be addressed at the stage of bail itself, given that that particular burden will have to be.
Well, I feel that Murana doesn't say so. The sentence will rely.
Yes,
There is also words of it's any evidence is burden of proof.
indeed, Your Lordship.
When some incriminating evidence would be put to the person
Mhm.
in the shape of evidence.
Right, Your Lordship.
Suppose prosecution gives an evidence.
Mhm.
They would be disclosing the evidence. then in that there may be eventuality where some question or some point arises where he is to explain in terms of provision, which twin condition says, I would say, section 45 doesn't say anywhere. Section 45 is very clear. Parameter section 37. You say that in no circumstance bail should be granted, but same time for that you have to first provide opportunity, and then court is to satisfy itself. In event of being allowed on bail, he will not indulge in these activities. Doesn't talk, but probably Vijay Mohan Chaudhary, the twin condition test was later on. But you the subsequently Tarkeshwar Shah, you say Tarachand, probably that has been further diluted now.
So you put your case very expensive, but arguing. But with my lord's permission, one more thing I would like to know.
Yes, sir.
It is section 19 which is being denied upon.
Yes.
It speaks of three things.
Yes, sir.
There should be material one.
Yes, sir.
Reasons of belief
Yes,
to
sir.
be given to the superior officer.
Yes, sir.
And then grounds of arrest
Yes, sir.
to be informed to the accused or the arrest.
Yes, sir.
Kindly see your arrest claim.
Yes, sir.
It speaks of reasons of arrest
Yes, sir.
which were conveyed as per this memo.
Right, sir.
And then it speaks that grounds of arrest have been explained.
Right, sir.
Would you say that reason and ground as used in this section are one and the same? One. Secondly, if this memo is defective, can the state get out of it merely by submitting that it was signed by the accused who was in custody?
All right. So, Your Lordship, this contention which I'm about to bring to this bench's attention, contention might be against me, but still, for the sake of this thing, Your Lordship, if I'm not wrong, in the case of Praveer Purkhayasa, there was a distinction made between reasons of arrest and grounds of arrest. Your Lordship, in the present case, it has been mentioned in para N of the Moot proposition and para N of the Moot proposition, para S of the Moot proposition, that the reasons for arrest were duly provided to him. And in reasons to arrest were provided to him, and in the arrest memorandum as well, it was provided to him in writing, as Your Lordship rightly pointed out. And it has been mentioned later on that that Dr. Comte had agreed that yes, I have been explained the grounds of arrest. So, Your Lordship, if as per the Moot proposition, there seems to be a little discrepancy on the same. However, with respect to it being defective, if we, without prejudice, if we do assume that the arrest memorandum is defective, however, in the present case, I have already satisfied my lords on the reasons to believe which were with the DFI in their custody, which is the complaint that was registered by Mr. Spencer, the FIR that was filed by the NBR, and eventually the ECIR that was lodged by the DFI. So these three evidence or proof serve as sufficient proof and evidence for. Yes, Your
It
Lordship.
says that you have done from 4 Qs.
Pardon, Your Lordship.
Please, we have given the name of some third person.
The wife of Dr. Kaur is the close relative, the father.
Yeah, Dr. Jeremy Coffey has been named as accused in FIR registered NBI. Where he has been made the doctor is a kingpin behind such a investigation has shown that Dr. Jeremy has mounted a physical crime to Aurora and has used the purpose of obtaining election. From where this information came to your knowledge.
So, Your Lordship, the FIR that was lodged by the NBI, there is a proper procedure that is followed by the NBI, and the same has been not been mentioned in the written submission, but the same has been applied from the website of the NBI.
Also, so we agree that this arrest memo or notified
Yes, Your Lordship.
is not to be an encyclopedia,
Indeed, Your Lordship.
but then at least there should be some material to satisfy us.
All right,
And this was conveyed to the arrestee or the accused.
right, Your Lordship.
And if you see arrest memo section 2,
Yes, Your
that the
Lordship.
state is strongly relying upon,
Yes, Your Lordship.
then you satisfy yourself whether this is material enough to deprive someone of article rights guaranteed or the fundamental rights guaranteed in Article 21.
Yes, Your Lordship. Your Lordship, as per the Moot proposition, there have been three sufficient proofs and evidence given to us, and the state has relied on that and brought this before my lord's attention. Secondly, as mentioned in para L of the Moot proposition, it shows that there was a preliminary inquiry that was conducted by the NBI, and this is precisely what I was about to bring to this bench's attention, that there's a proper format which is followed by the NBI when there's a complaint registered or filed by a foreign national. And they cannot just lodge an FIR directly. If my continue that they cannot directly.
Permission. What is there in the Moot notes
Yes, Your Lordship.
are allegations.
Indeed,
Now these are to be supported by material.
yes, Your Lordship.
Material which has been given to the accused or supplied to the accused or made available to the accused, and which has been supplied to this court.
Yes.
Now, material is the arrest memo.
Yes, Your Lordship.
Your Moot proposition cannot go beyond the arrest memo.
Yes, Your Lordship.
So, we say how do you justify this arrest memo?
Your Lordship, the arrest memorandum, first and foremost, what I was trying to contend and issue to in the beginning was that the basic provisions that are there that needs to be complied with while conducting or while having an arrest was duly complied with the respondent in the present case. The arrest memorandum is something which has been given, which is a part of the Moot proposition, and as Your Lordship rightly pointed out, is the only material we have.
No,
But apart
no,
from
why did he put this question to you? Because this is with reference to your argument that by giving this, we have already covered section 19. It says that he is to be given information.
yes, Your Lordship.
Though at first instance you said that oral information is sufficient, but now at least by placing lines from this document, you can say no, written document was given.
Yes,
But whether this written document contains any information, simply allegation that we have learned 20,000 crore का बाहर फेंक दिया, is it sufficient?
Your Lordship, as rightly
At least you could quote 2-3 instances that this has come investigation, this is copy, this is cover memo, this is your passport, this is a bank transfer.
yes.
That is the
Your Lordship, this would like to respectfully disagree with my laws in the present case, as it has been mentioned in para M, and then subsequently para N, the press note that was released by the DFI clearly lays down that there was an investigation. I'm coming
Press
to
note?
my,
press note.
no, Your Lordship. So I am mentioning that the
When
only
we are talking
evidence.
about rest memo, because that would be tested.
I'm trying to get my.
Subject, because when we talk about compliance of section 19, first document relevant notification will be a test memo.
Right, Your Lordship.
Because in the basic case there, that is the only case.
Yes, yes.
There's no reason for assigned.
Yes.
I was simply picked up on my own. And that's the violation of my right. Section 21.
Yes, Your Lordship.
Ms. Counsel, with my law's permission, we may or may not agree with you, but all of us are very appreciative of the way you have defended this case.
If I may just.
You may conclude, please.
Yes, Your Lordship. So I was just trying to bring this to the court's attention that with what preliminary and limited evidence we have, I've already brought that before the bench's attention.
One thing, you know what's the purpose of organizing such meet courts? To hone your skills.
Indeed, Your Lordship.
Increase your confidence
Indeed, Your Lordship.
and to make you aware of the court proceedings.
Yes, Your Lordship.
And first and foremost thing is that whenever any counsel argues, first the officer of the court
Yes,
is
Your
to be truthful to the court.
Yes,
उसको ये नहीं देखना कि मेरा client है किसे first he owes it to the court.
yes, Your Lordship.
That's why he is considered the officer of the court.
Yes, Your
So
Lordship.
sometimes you have to leave the interest of the client behind and you have to speak truth.
Yes, Your Lordship.
This is all purpose of these courts.
Yes, Your Lordship.
And that will give you discretion of the court.
Indeed, Your Lordship.
It happens.
Yes,
Very conduct of lawyer.
yes,
Sometimes you know that changes the game.
indeed, Your Lordship. Your Lordship, that's why I gave a content which was against me when I differentiated between the same. So, apart from that, if I'm happy, much obliged for a candidatation, Your Lordship.
The council seeks permission to begin with the rebuttal. Your Lordships, the respondents have based their issue to arguments on the case of Moot Qureshi versus Union of India, which is a Delhi High Court judgment. It is a humble submission that this judgment stands overruled by the case of Pankaj Bansal versus Union of India, and the same is present. And the same is at page 33 of our compendium, para 45, it clearly states that the decision of Delhi High Court in Moin Akhtar Qureshi, which which holds to the contrary, does not lay down the correct law. The case of Pankaj Bansal, which mandates that written grounds of arrest have to be provided, it provides two reasons for the same, which is mentioned on page 32 of our compendium. Your Lordship, the court clearly states that there is no valid reason as to why a copy of such written grounds of arrest should not be furnished to the arrested person as a matter of course without exception. It states there are two primary reasons as to why this would be an advisable course. The first reason is that in the event such grounds of arrest are orally read out to the arrested person or read by such person with nothing further, and this fact is disputed in a given case, it may boil down to the word of the arrested person against the word of the authorized officer as to whether or not there is due and proper compliance in this regard. Further, the case of B. Senthil Balaji clearly states that non-compliance in this regard would entail release of the arrested person straight away. Therefore, we submit that written grounds of arrest had to be provided. Further, in the case of Praveer Purikas, the court has clearly stated that these written grounds should be adequate. That means that the person should be able to give an adequate defense. However, if we look at the arrest memo, which is on Annexure 2, the grounds provided are very vague in nature. Therefore, we submit that it is violative of Article 21 and 22. Further, Your Lordships, the respondent have stated that we should follow strict rule of interpretation. However, it is our submission that there is also golden rule of interpretation. The Article 22 clearly states that the accused has to be provided with, has to be informed about the grounds of arrest, and Section 19 of PMLA has to uphold the constitutional safeguard. Therefore, as per the purposive interpretation, written grounds of arrest should be provided to the accused or the arrestee, which is also mandated by the court in the case of Pankaj Bansal versus Union of India. Further, Your Lordships, the reason to believe, as the respondents have argued that they had reasons to believe to arrest Dr. Jeremy Compton. However, it was also only on the basis of one report, one complaint that they had received from Mr. Robin Hood Spencer. So therefore, we cannot say that report would serve as the objective criteria to form reasons to believe, which, if I may add, reason to believe also has to be furnished to the arrestee or the accused as mandated by the case of Arvind Kejriwal, and in the present case, they had not done so. So the accused, so Dr. Jeremy Compton was actually left with no material to defend his case. Further, Your Lordship, the respondents have also argued that there was a necessity to arrest Dr. Compton. However, it is our submission that there were less restrictive measures also available. For instance, they could have issued summons. If you look at the case of Arvind Kejriwal, before he was arrested, there was 7 to 8 summons issued, and it was later because of non-compliance he was eventually arrested. Therefore, it is our submission there were less restrictive measures available. Further, coming to the next contention of the respondent, so they've argued that the legislature has the power to frame separate conditions for bail, and we do agree. The legislature has the competence to frame separate conditions as per different penal provisions. However, it is a submission that the twin bail conditions as provided under Section 45, they are disproportionate because the person or the arrestee he does not have material to prove that he is not guilty. Therefore, we submit that these conditions should be relooked. Further, just one last rebuttal. Your Lordship, further the respondents have argued that under PMLA, there's a huge burden on the prosecution to prove that the accused has committed an offense, and because of this, reverse burden should be there. However, it is a submission that this cannot be a ground to uphold the validity of reverse burden. That's all from my side. Thank you.
You were saying that this memorandum of arrest detailed grounds of okay. We would want to know whether this provision it envisages absolute compliance or would it amount to substantial compliance and that will be sufficient requirement.
Indeed, Your Lordship. So this particular provision, as interpreted by the court in the case of Pankaj Bansal and B. Senthil Balaji, they have clearly stated if written grounds of arrest have not been provided, then it would lead to release of the accused. So that means absolute compliance is necessary. That's it.
Your Lordship,
I may begin. Your Lordship, first and foremost, as my opposing counsel pointed out that that Dr. Kong was not given enough due compliance, that there was not enough reasons for his arrest. So, Your Lordship, it was not the case, and as I've highlighted in my submissions, that it was not the case that he was totally blindsided and was not exactly aware and oblivious of the reasons for his arrest. Secondly, Your Lordship, my opposing counsel pointed out the Moin Akhtar Qureshi judgment being overruled by the consequence of judgment. To that, I would like to bring my law's attention to clarification number 24, which states that all judgments of the Honorable Supreme Court as well as of the Honorable High Courts will have only persuasive value for this competition and no judgment will be considered binding. Hence, that's precisely the reason why the respondent had borrowed that particular principle from Moin Akhtar Qureshi. Secondly, with respect to all the aspect of written grounds of arrest being under purposive interpretation, Your Lordship, as I've already submitted, that we need to take literal interpretation of the legislations into consideration, and that's how the bench. I mean, that's the humble contention that's how the bench should interpret it as they. Lastly, coming on to the reason to believe, I've already tried to satisfy your nerves on the evidence and proof aspect of the reasons to believe. And I would like to highlight again that there was a preliminary inquiry that was conducted by the NBI, and there is a proper mandate of how a complaint is registered with the NBI and how the NBI actually lodges the NFIR on the same. There's a 5-pronged test on the same, and it is not like they randomly choose any complaint they want to go about, and that's how they go about their investigation. That is primarily all the points. Those are primarily what the contentions are based on. Honor to argue.
Thank you.
This brings us to the end of the oral argument. Thank you, participants. It was truly a delight watching you all today. I now request the judges to give their valuable feedback to the participants. It was truly an honor for HPNLU and participants to have the panel with us today. Thank you.
Thank you to all the attendees for witnessing the intense final round. Now we will take a 10 minutes break, and after the break, we will proceed with the valedictory ceremony. Thank you.